Awesome. Good afternoon, everyone, and welcome. Welcome to today's webinar on navigating seller disclosure, everything property lawyers need to know. My name is Matt Tarabay, not to be confused with Matt Dunn, one of the stars of today's show. I am Head of Marketing at TriSearch and pleased to be your host for today's webinar. We have an action-packed session ahead where we'll get to hear from experts around the industry on their insights on the new seller disclosure regime. Excuse me, before I get to the agenda, some quick housekeeping. If you cannot hear me or have any audio issues throughout, please utilize your Q&A box at the bottom of your screen. We'll do our best to sort out the issues as we go. Similar to that, if you have any questions throughout, please also type them into the Q&A box and we'll have dedicated time at the end of the webinar to answer. Anything we don't get to, we'll make sure we follow you up afterwards. Fantastic. We now turn our attention to the agenda of today's session. So I am joined by a trio of superstars who you can see on screen. First off, we have Matt Dunn, the CEO of the Queensland Law Society. Matt will be talking through the QLS perspective on seller disclosure, some of the key concepts, practical tips, and some more of the granular requirements. Following Matt, we then have a panel discussion headlined by Managing Director and Principal Lawyer at Colwell Conveyancing Group, Nic Gould. Nic and his team have been living and breathing the new regime and will take part in a discussion with myself and Matt on how they're successfully navigating their way through it. Finally, we'll have our very own Jeff Hayes, Product and Enablement Specialist at TriSearch. Jeff will be showcasing the tech solution available to remain compliant and assist in your efforts with seller disclosure. Then to cap off the session, we'll be answering questions live from the floor. As a reminder, you can type these questions into your Q&A box at any time. Although he needs no introduction, in a few seconds I will hand over to Matt Dunn. Currently serving as the Chief Executive Officer of the Queensland Law Society, Matt is a leading voice in property law reform. With nearly 2 decades of experience in legal policy and advocacy, he has already played a key role in educating practitioners on the seller disclosure changes. Matt's extensive legal expertise and leadership make him a trusted authority on these reforms and how they will impact Queensland practitioners. Without further ado, I will now hand over to Matt Dunn. Over to you, Matt. Just call out when you'd like the slides to be flicked.
Thanks very much, Matt. If we could move to number 1. And welcome, everybody. We are going to go on a lightning fast adventure journey through the absolute joy that is the seller disclosure regime for Queensland. This has come to us courtesy of our new Property Law Act 2023 that has commenced. It is filled with adventure. It is filled with excitement. It is filled with joy, laughter, and the occasional tear. So we're going to go on a bit of a journey there. Matt, if you can jump over to the overview slide for me now. Thanks very much. Just to give you a bit of a signpost about where we're going to go today, I'm going to talk about some key concepts. We're going to focus a little bit on the Form 2 itself. We're going to have a talk about the prescribed certificates. There's a lot of confusion around some of those. There's a few different perspectives. We're going to narrow down on a bit of that and try and dispel a few of those myths. And then we're going to talk about a few FAQ and practical tips if we end up with enough time left over. So starting with those key concepts, let's have a talk about that. The reality of the situation is that we are no longer in Kansas, Toto. The property market in Queensland has gone absolute gangbusters and has gone gangbusters for years. The median house price back in March for Queensland, all of Queensland, was $810,000. The median price for units was $645,000. That is very serious coin. We are talking about significant money there. So why do we need a vendor disclosure regime? Well, part of it is, as you've seen, the money is big. We're dealing with a lot of money. We're dealing with very big investments, probably the biggest investment that most people are going to make in their entire lifetimes. The REIQ CEO has talked about the selling of a pair of shoes and said property sales are not like selling a pair of shoes. And she is absolutely right. Because in the context of a pair of shoes, you've got the Australian consumer law, you've got certain guarantees, you can get a refund if the shoes that you're buying are not of a merchantable quality. You don't have that with an $800 million property. You don't have those things. You're really on a bit more notice. So there's a lot of things that we need to do. You also, if you go and buy a car, for example, you get a roadworthy, and you've got to do that before you sell. And everyone accepts that as a part of that. There's good rationale for that. Moving that similar protective concept, that little bit of information concept into property is probably not overdue. Here in Queensland, it's probably timely to do that. And it probably makes it a good big thing. It's just new. It's new for the property industry, but ultimately it's similar to what we see in other jurisdictions. And as you've seen by the timing and the money, it's worthwhile. So why is this a good thing? That's an interesting question. It's a good idea for buyers to know a little bit about the property that they're buying. What is it, the product that I'm actually buying? What do I, when I go into that? I think that's a fair thing to do. It's a good equitable thing to do. It's also, if the buyer knows a bit more about the property they're buying, then we've probably got a chance of contracts falling over less. And that's a particularly good thing. I think one of the best and biggest parts of the new regime that is going to be helpful to us as we go forward is traditionally in conveyancing of real property in Queensland, you come to learn about that big, horrible, scary thing. And the big, horrible, scary thing normally turns up on day 23 or day 24, and everybody goes to custard. Nobody knows what to do. Everyone starts looking at each other, pointing fingers, and it's all generally disaster. Imagine a wonderful world where you could come to know about the big, scary thing, hopefully before you sign the contract, but let's be charitable and say you learn that on day 3 now. So you actually now have at least probably 25, 26 days, hopefully longer, to actually negotiate, deal with that, and work through what that actually means. And that is a good thing. That's a positive change. That's a positive change that will mean deals won't necessarily fall over because people don't go to custard. It'll save the mental health of the conveyancing industry. And I really, really like that as an outcome. And also too, it'll save settlements because there won't be the big scary thing appearing later on. So what does this new thing kind of give us that we didn't have before? Well, it gives us a new opportunity for cooperation. It really gets the lawyers and it gets the real estate agents in at an earlier stage, starting to talk about the property. And it means that some of the stuff that would otherwise come up as the big scary thing is known a lot earlier, and we can all get on with actually working through what we need to do. And those are excellent and wonderful things. So Matt, can we just jump over to the next slide if we could, thanks. The heart of the entire regime is this new section 99, and it says a couple of useful and interesting things. It says that before a contract for the sale of lots signed by the buyer, the seller must give the buyer the disclosure statement, which is in the approved form 2, and the prescribed certificates that are applicable to the lot. We're going to come back to that concept, applicable to the lot. There's also a little wonderful thing that says there's no contracting out or a waiver of obligation unless there's certain types of exemptions that are listed. I'm not going to go through all of those today. You can look them up. But what it means is we've got a regime that we need to deal with, and we need not a way to get around it. So what this also doesn't do is it doesn't say that there cannot be a settlement if these obligations are not met. What it does tell us, though, is if these obligations are not met, there are consequences. There's potential consequences that could flow, but it doesn't necessarily stop deals from happening in the first place. So let's dive, if we can, Matt, over our next slide, if we could, please, which is our disclosure document holding slide, and the next one after that, which is our Form 2. So our Form 2 is a beautiful thing. It is our 6-part excitement where we put all of the material in and we get that. It is the approved form, as you well know. It has to contain both the prescribed information and prescribed warnings. Happily, it does actually do that, and it contains what it needs to contain in order to be able to meet the requirements of the property law regulation, where all of the particular items that need to be disclosed in the aspects are set out. It provides a lot more information than that. Interestingly, too, the form provides a place for the buyer to sign at the end, and that isn't a legal requirement to have the buyer sign that. It can be a good idea, particularly if it's handed over in physically, but it isn't necessarily required, but the seller must sign, or the seller's agent. So that's kind of where we go. If we jump to the next slide, Matt, if we could, please. There's a really important point here with respect to the Form 2. There's lots of good information on that form. It's the center of the entire regime. It's easy to access because most of the information there is not descriptive. There's a couple of descriptive bits, but mostly it's not descriptive. It's yes, no's. Like, is this affected by this? Yes, no. Is this affected by this? Yes, no. Is it affected by this? Yes, no. And what's important about this form too is that it must be completed with information that is true at the time that the statement is given to the buyer. So the buyer can rely on the information that's there. And if that information is not true, then there is the ability to terminate. And there is some materiality test to that, and there is some stuff. If the form's not given at all, then there's a termination right that flows. Again, this regime doesn't stop deals. This regime doesn't stop settlements. It doesn't stop people buying and selling, but it means that there are consequences if the information that people should have is not there. And it also says that the information can be relied on. And so one of the key things that we'll come to see as we go on is that the information in that form 2 is really valuable. The tick boxes are valuable. Relying on that is valuable, and it can be a really important part of the process that we're doing. Now, I wanted to talk next slide, if we can, Matt, on the prescribed certificates, because this seems to be the part that's gathering the most attention. There's a lot of misinformation out there in the media. There's a lot of people giving their impressions. They've not read it. They're talking about different sorts of stuff. And I think it's a really good idea to just hone in a little bit on what's actually the meat. Like, where is this really there? So prescribed certificates are a bit of a misnomer because even though it says certificates, most of the time they're not certificates. They're mostly notices or documents or particular things. And so it's copies of stuff. And there's a bit of a rationale behind all of this. So it's stuff that the seller should have knowledge of because it's something that they should have been given. The prescribed certificates are something that someone should have foisted on them that they should have some knowledge of in order, and then should be able to produce in order to be able to give to a prospective buyer. So these are situations where it's something that is relevant to the sale and is something that can be particularly given. Now, in terms of some of the mechanics around the prescribed certificates, this is not PAMDA Form 30C. This is not staple documents in a particular order. This is a bit more free form. You can provide the documents separate to the Form 2. You can give them in any order that you like at any particular time, provided that they're given prior to the contract. If documents are missed, if they are not given at all, then there is that right to terminate, the consequence without a materiality test. So, you know, some people have said, well, do I need to give it all together at the one time? The answer is no, you don't have to. Maybe it's a good idea to give most of it together at the one time, because that way it's less likely that something will be missed. Because if you dribble out the certificates over a period of time, the chances are one of them could well be missed. And then there's a consequence that can flow from that. So let's have a look at then, Matt, if we can go to the next slide, about, well, what are those certificates? And so the first one that we've got is a title search. And that's a particularly useful and powerful thing that generally would be done as a matter of a transaction in any event. Also a copy of the plan that's registered under the Land Title Act as well. And that's another useful and relevant document and it's amazing how much information about a property you actually can glean from your title search and your plan, which is a really useful and important part of the notice process. The next thing that I wanted to call out was the owner builder notification under Section 47 of the QBCCA. And that's an obligation that already exists under law. It's a separate obligation. It already exists. It already has to be done. There's nothing new other than it's just been packaged into the process that we already have. It's also really important piece of information for a buyer to get, because it tells them that they're outside of the compensation regime. It tells them that they're potentially on their own, and it tells them that they perhaps need to take a lot of extra care in their building and pest inspection. So it's a really important thing to get at that early point, because there's consequences and there's interesting things that should sort of flow from that. Matt, can we jump to the next one? And I think there's a little bit more we need to deal with here. So here we've got the contaminated land notices, we've got the show cause and enforcement notices for the Building Act and the Planning Act, we've got notices of work to be done. We've got neighbourhood disputes, transport infrastructure and pool safety certificates, or my personal favourite, in the universe, which shows that humanity has reached a level of evolution beyond which it is impossible to move, the notice that there is no pool safety certificate in existence. So these are all a bit of an interesting cohort, because these are things that you can do a search to find out potentially if this is in existence or not in existence. And that's a great thing. And that's really good to find out. The prescribed certificate, though, is not the search result. The prescribed certificate in these cases is, the regulation tells us, a copy of the notice. It's a copy of the document. It's a copy of the order. It's a copy of the application. So it's the actual operative thing. And if you think about it, that's the stuff the seller should have got from the relevant authority, from the court, or otherwise. This is something the seller will have been given that they will hopefully have or can be obtained. But the search is useful because the search will put you on notice that it does exist. But ultimately, it's about getting a copy of the relevant notice, order, or whatever from the seller, which means in order to do this work and put this stuff together, you kind of got to be able to speak to the vendor. You've got to be able to get that information out of the vendor as a part of the process. So it's more sophisticated a process than just simply printing out a bunch of searches and attaching them to the back of something else. We're not in a New South Wales centric kind of disclosure system where it is just a bunch of searches that are attached to a document that people don't look at, and it's also relevant that point that we had before where it said the prescribed certificates need to be given if they're relevant, which means if those notices are in existence, they need to be given. If the notices are not in existence, then you need to tick no on your form 2, and then nothing needs to be given in the circumstances. So there's always a bit of question, do I need to provide a null search or not? Now, the legislative regime does not require you to give a null search. It doesn't make you hand that over. There might be good reasons why you might want to do that in order to be able to show to the buyer that there isn't an issue with that particular piece of property and be able to demonstrate that. You should remember, though, you should be able to rely on the ticking of the no on the form. And if that's wrong, you've got termination rights that can flow from that necessarily in certain circumstances. So, it's a bit of a thing. There's nothing wrong with giving the null search results, but the legislation doesn't force you to do it as a prescribed certificate. It asks you to put the relevant documents, the relevant notices into the thing. I think the other thing that's probably worth noting about this while we've got a moment for that is these things here are important. Some of them are defects on title. And as we all know, defects on title have had to be disclosed prior to contract under the common law since at least 1888. Well, or even before then, potentially. Defects in the quality of title, and some of these are those, are things that don't traditionally have to be under the common law, haven't had to be disclosed. But the legislative schemes have required them to be disclosed because they're important, because they're material, because they're relevant. And these things are also things that traditionally are included in the REIQ contract, particularly as relevant warranties that the seller is giving. So these are not new. These are not unforeseen. These are things we should already have been dealing with through the process. If the seller's giving a warranty that something doesn't exist in the contract, then it's good to actually deal with the fact that it doesn't exist. And otherwise, it can be something that causes problems in the conveyancing process down the track. So I think there's some relevant parts that we need to deal with in that. Matt, can we just jump over to the next one? There's a couple of things around body corporates at the moment, and there's a bit of a bumpy ride, and undoubtedly we'll talk a bit more about body corporates as we go on, because that's a bit of an interesting issue for the moment. What the prescribed certificates require us to do in the regulation is to provide the most recent community management statement for the scheme, and also the Form 33, which is the body corporate certificate. There's a separate issue for Bugda. I'm not going into that today. Or there's the statement that you can give under Section 7 and 8, which is the no certificate. And there's only very limited situations where you can provide the no certificate, one of which is where the records of the body corporate are in such a disarray that it is impossible to be able to reduce the information. And if you think about the regime, maybe that sort of approach is actually quite useful, because if I'm a buyer buying into a body corporate and the records of the body corporate are in such a disarray that you can't produce a certificate, maybe that's something I should know before I go in, because I know I'm walking into an absolute disaster of a body corporate. Doesn't mean I don't want to buy the unit, doesn't mean I don't love it, but at least I'm on notice that maybe there's a problem with the body corporate and it's not going to be necessarily smooth sailing. And that's something I should consider when I'm going into the process of buying the particular property. So there's a bit of moving part there around some of the body corporate certificates and where they're kind of going. Matt, can we jump over to the last of the slides? Now, I promised you that this would be fast, it would be furious, and it would be many things. The last bit I wanted to mention as a bit of an FAQ was the issue of evidencing delivery. And I think this is another thing it's important to kind of call out. So the seller needs to prove that they provided the material, they provided the certificates, and they provided the form too. You can provide these things in a number of different ways. You can do it personally, you can do it by post, you can do it as an attachment to an email, you can use it inline in an email, you can send an email or a communication with something like a DocuSign link or an electronic link. So I think what's interesting to consider in that is that it's important to both check the delivery methods that you are doing, but also take some proof of that. So it might be, for example, if personal service, you might want the signed acknowledgement of the form too. You might want a signed form that says I've received these certificates or something. If it's post, it's now, I think 7 days after posting is the time the postal rule will tell us, which is a long time. So that's where it is. Maybe you want to take a photo of what you're sending. Maybe you want to do a timestamp. I don't know. If you're doing emails, perhaps you want to take a copy of that email. Perhaps you want to put a read receipt on it. Perhaps you want to show that the links that are in that are viable and working at the date that you actually send it. Because ultimately, the fights that will turn up around this will be fights about whether that material was delivered or whether it was available. And the best time to create evidence is at the time something happens, not afterwards, because that's kind of dodgy. So my call out for you as a bit of an FAQ is think about the method of delivery, but also how to make proof that the delivery has been done. That's what I got for today. A bit of a whirlwind. Thank you.
Thank you very much, Matt. Very valuable insights. We've already had a couple of questions come through. The themes seem to be around body corporate as well as prescribed certificates. So we will get to those at the end. But thank you very much, Matt. Ladies and gentlemen, don't go anywhere. We will now kick off and head straight into our panel discussion. So I would like to formally introduce you to the Managing Director and Principal Lawyer of Colwell Conveyancing Group, Nic Gould. Nic shared the same uncertainty of seller disclosure as the rest of the industry. However, with preparation, research, and by staying ahead of the technology curve, Nic ensured his firm was set up and ready to go from August 1st. Nic has built a thriving legal practice in Queensland through his commitment to fostering relationships, leveraging tech, and optimizing customer experiences. Welcome, Nic.
Thanks, Matt. Appreciate it.
Good to have you here. So for this panel discussion, I will act as chair and facilitator. We have questions submitted during the registration process for the webinar that both Nic and Matt will share their perspectives on. So to get us started, question for you, Nic. Seller disclosure has now been in market for 3 weeks. Can you talk to how you have implemented the offering in your practice?
Yeah, sure. It's a good question. So it's been a long 3 weeks. Our journey probably started well before that. And so we decided at our firm we were going to implement effectively a separate business unit inside the business that directly tackles disclosures. So we have a disclosure team, and that team is a resource team. And so that's how we offer in our business. So effectively, sellers come in, they first engage with the disclosure team. The disclosure gets prepared, onboarded, prepared, sent to the agents and the client. They go and sell the property, and then they get transitioned across to our legal team for the transaction side of it once it's sold. So that's how we've implemented it internally. Again, every firm's a bit different depending on size and volume and specialization. I mean, all we do is residential and commercial property. So we've had I guess, the beauty of having just a disclosure team.
Yeah, really good. Matt, have you seen anything different across the industry from the way Nic has implemented it in his firm?
Oh, look, some people are putting it into their ordinary conveyancing process. Some people, I think, wisely, like Nic, are setting it up as a separate advice service that they're providing, which I think is the better way of doing it. They're carving out a separate retainer. They're providing a separate fee, which I think makes a lot of sense. They might connect it to the conveyancing work that they'll do following, and I think that's a very sensible thing to do. But actually really trying to sell the value of the engagement that the lawyer can bring at that early part of the process, and also kind of maybe communicating that how that then has the benefit later on in the conveyancing process around the settlement, because getting the lawyers in early means that you can nip in the bud a whole lot of stuff that, as I said, the big scary stuff that had come in down the track. And so dealing with that as early as possible just makes better settlements. It makes things actually work better. It gets the straightest possible line from when everyone's excited at the beginning when they sign the contract to the end point when the settlements happen. And the best thing that could happen out of everything is that there's no surprises.
Matt, can I add maybe a couple of things there to what Matt said? So we've with our disclosure regime, so we're collecting things such as VOIs. We're even collecting if they're continuing with us with the conveyancing, we hold off all costs until settlement. But importantly, we then do a client authority not only for the disclosure but for the sale conveyance, and we're even collecting the ATO cert at the disclosure stage. So our clients are effectively set up, and then the matter gets converted from a disclosure matter to a sale matter. And from our early days, we're already starting to see transactions come through that from our disclosures that's been actually made the sale process really, really smooth. Because as Matt said, you're able to see those red flags at the start. You're able to prepare your sellers. Anything they might need or will need, we're getting at the early start. So it's just a nice, clean transition across to the legal team and the conveyancing team.
Yeah, interesting. You touched on it, Nic, but how has technology assisted in that implementation in your process?
Yeah, look, I think if I'm really honest with myself, I probably thought the Form 2 process was going to be a bit easier than what it's proven to be. And I say that because sellers just aren't as prepared as what they've had to have been in the past. You know, agents aren't as prepared as probably what we've been in the past. In an ideal world, it's a really kind of linear workflow. But, you know, as we know with conveyancing, with property law in general, it's never a nice linear workflow. There's always some exemptions and things missing. And, you know, even down to things like, you know, send us your water and rates if you've got them. And people will do, you know, send us the front page, which, you know, to every day, that's probably all you need to know, because it's got a balance due and a date and you pay it. Well, you know, with the water, we need to know the access charges, right? So we need the second page. So it's little bits of education that we've sort of learnt that we need to focus on in our onboarding. So to go back to your question, we've implemented, we use TriConvey as our main legal software, but we also integrate that with HubSpot, where we've got our own individual workflows. And that really, so our CRM focuses on client and agent communication. So we use a series of emails, text messages at certain points. So when we open a disclosure file, when we've received searches, when it's been sent out for signing, and finally when it's sent out. And we also have internally some AI capability internally, some multi-agent AI capability. And so, yeah, we've kind of gone, I guess, a multi-tech kind of solution, which seems to be working. But there was no doubt, though, at the start we were kind of doing a lot of it manually, only because we needed to know where the pain points were. So we're finding it, and we're smoothing those friction points out now, I guess. So it hasn't been completely smooth sailing, but we've learned a lot in 3 weeks.
Yeah, okay. I was going to say, Nic, are you at set and forget at this point, or you're still at
No, we're far from it, Matt. I think you know, and it's really the little things that get you right. I use the example of the second page of the utility bill, right? So that's one example, and there's probably 100 of those. But we're far from set and forget. We're on the journey. We've, as I said to my team, we're kind of building the plane as we flew it there for the first few weeks. But we've learned a lot, and we're in much smoother waters now.
Yeah, really good. Another question that popped up quite a bit during registration. For you, Nic, has the way you onboard your clients changed? Is there now a greater importance placed on the way you onboard your clients?
The answer to that is no, but we've always had a big emphasis on onboarding. So if there's one part of our process that is where the time and resources go to, it's onboarding, because we pick up those flags at the start. So my view has always been that onboarding sets the tone for any transaction or relationship going forward with that client. So we really focus heavily on onboarding. And so we've taken the same approach with disclosure. And as Matt said before, being able to identify those red flags early has actually made the sale transaction super smooth, because even little things like if you're going to do all the searches and you've got the tools to do the searches, just get the client's ATO cert at the disclosure stage. So at least then you've got it, or at least then they've got time. For some of our older clients who perhaps haven't done a tax return in 30 years, or some of our corporate clients who, it takes longer to get ATO certs. All those little things we can get early. We can get their ID early if they need to order birth certificates, or any of those kind of funny ones we sometimes see. We're getting them early.
Yeah. Okay.
Could I just add that Nic's ideas are always great, and particularly in this place, focusing on onboarding is a really important part, because that's a part of the formation of the relationship between the lawyer and the vendor and the client. That's really important. Getting that sort of relationship off to the right start is also really important. And given that next year we'll all be working on the joy that will be the money laundering and counterterrorism reforms, that's going to bring us back to the importance of onboarding, which is everything that Nic's just talked about now. So Nic's always ahead of the game, and bringing this stuff to the forefront and doing that at the early stage and getting a good relationship, getting a good rapport. The client understands the value in the lawyer. The client understands the value they're getting. The client understands that the legal process is more than just mechanical transactional stuff. It's a person bringing some experience and knowledge, as well as the leverage of technology, which is also critically important. And then you just set up really well for the future and what's to come.
Yeah, really good. Thank you, Matt. Thanks for the insight. Another one for you, Nic. Well, this one's for the business owners out there, but Nic, how do you balance the commercial risk to your bottom line versus the legislative risk from the new regime? I.e., how are you ensuring you're both profitable and compliant?
Yeah, it's a good one, and it's always a challenge in our industry to get that, I guess, the pricing right, but also balancing risk. And I don't have a golden solution here. It depends on your firm. It depends on how your business operates. It depends on where your business comes from. All of those things come into it. What I would say, though, is that it's a legal matter. You assume risk by taking these matters on. You assume liability by taking these matters on, and you use resources to do it. Be it human resources, or be it tech tools, or be it time. These are all things that get consumed to do this. So therefore, it should be profitable to your firm, because if it isn't, there's no point in doing it. There have been some firms who've come up and said, we'll do it for free, or we'll do it for $200 or whatever. And I congratulate them and wish them well. But that's not a game that I'm interested in. And I don't think we should be interested in as an industry, because one, it devalues what we deliver. And it basically devalues the service to the client, because the client doesn't see value in actually what we're doing. It becomes I guess, as Matt said, a machine kind of, transactional relationship, which is not how it should be. These things have real ramifications to people on sometimes the biggest asset of their lives. So we need to take that seriously. So to answer your question in a roundabout way, Matt, it's not easy. And it does depend on, it even depends on your demographic you're working to, all those kinds of things. Clients will always look for a cheaper option. And so part of it is in that process of education in the lead stage or the onboarding stages around showing the value on what they're paying for. That's really, really important. And in our firm, if people want it for free, well, there's other providers out there, and all the best.
Yeah, Matt, you were shaking your head quite aggressively there as Nic was talking about devaluing services. Have you seen that?
Oh, look, absolutely. And I think we do it to ourselves too often in the law. We really have to learn to value the service that we're providing, to value the work that we're doing. It is good work. It's important work. It's valuable work, and it needs to be charged accordingly. And like Nic would do it as a separate item to say, this is a valuable service. And in that communication with the vendor, I mean, you can say that, look, we're saving you from the big, hairy, scary, terrible thing that might come up at the end of this process that's going to scuttle your deal. So spending a little bit of money now to get things right is ultimately going to back things in later on and put you in a much better position. And so you're, like, it's a really valuable service people are providing. And so, my message through the road shows and otherwise has always been, like, charge appropriately, charge more, because really this is valuable. This is a valuable piece of work. And it also puts the lawyer in a position to be able to communicate that value to the client. And that's the onboarding thing that Nic talked about. It's kind of just getting that up front. And that's, I think, really important. So I just endorse everything Nic said. I think that's absolutely correct.
Yeah, awesome. Gentlemen, I'll ask one more, and then we've had a flurry of questions through the Q&A box, so I want to make sure we allow plenty of time at the end to go through them. So, Nic, this one again for you is seller disclosure. How has it affected your relationship with real estate agents?
Yeah, mate, good one. It's an important one. I think I'll premise this with, if it's done well and correctly, it should absolutely have a tenfold betterment to your relationship with agents. So one thing that this has done for our industry is put us from the back of the conversation, i.e. once the deal's signed, the seller goes to the agent and says, well, what's conveyancing and who do I use? And, they might refer you, or you go to Google, to actually the front of the conversation. And so someone wants to sell their house, they might sign a Form 6, and then they've got to they have to go and get their disclosure. That's brought us forward in the conversation, which is super important, right? So previously we were behind building and pest inspectors and the broker, and now we're at the front of it, which allows, we're an enabling function to a transaction. So you should be seen that way. So I think it's actually done loads of good that we probably couldn't have done otherwise for that relationship with the agent. So yeah, from my perspective, fantastic. And it's actually, it's had a remarkable effect on relationships.
Yeah. And Matt, did you have any insight on that perspective?
Oh, look, I think the opportunity for the cooperation between the agents and the solicitors in this process is amazing. And I think it's a matter of everyone just we'll come to see very soon. This is about saving deals. This is about getting things to work. Selling property is not about a race to contract and then not worrying about what happens after that. Like, the process of selling a property is what happens on settlement day, and it's everything that happens before that. And so when we look at it as everything that happens before settlement day, lawyers are a really important part of that process, and being in it is just really important. So, even the agents, it's a great opportunity for them to be able to understand the property and deal with those things that might otherwise come up and scupper the contracts and potentially delay their commissions. And, nobody wants that.
Depends, Matt, if you want to add Form 32s and the delays on those. But anyway, we won't.
True.
Another discussion for another time. Gentlemen, thank you so much for those insights. Nic and Matt, your insights and your candid commentary, very much appreciated. We will keep the session moving along. As I mentioned, we'll get to those questions right at the end of the session that participants have been putting through. But for the time being, we will now get a preview of the technology solution available through TriSearch to assist you with seller disclosure. I would like to formally introduce you to the product and enablement specialist at TriSearch, Jeff Hayes. Jeff brings over a decade of experience in customer solutions with a recent focus on legal and conveyancing tech. As a product and enablement specialist, Jeff has been instrumental in the rollout of Australia's most widely used conveyancing technology, TriConvey, advising hundreds of conveyancers, if not thousands, on tech best practice. Recently, Jeff has been focused on assisting lawyers and conveyancers operating in Queensland with their tech implementation around seller disclosure. Jeff, over to you to showcase our solution.
Fantastic. Thank you, Matt. I've just made notes on that. I'll add that to my next salary review. Thank you. That was awesome. Awesome. So yeah, thank you, everybody. Today I'm going to run through a demonstration on how to create our Form 2 seller disclosure through TriSearch, and also some basic navigation around the form itself. Let me start by sharing my screen. Alrighty. Hopefully we should be able to see that one.
Yeah, we've got that.
Okay, awesome, cool. Alrighty. So to access the seller disclosure, I'll first demonstrate through TriConvey, obviously our practice management software, and then once we get to the landing page, our website users or those who use our website on the call here should recognise where we are. We're going to give this a crack live. If I do get the internet death spiral, I have prepared some documents to keep us on time and moving forward as well. So first, we're going to click on the TriSearch tab within our Matter, and then we're going to click on New Search to launch our TriSearch website. Let's drag that across. Cool. Once we're here, give it a second load. Once we're here, if we haven't already pinned our seller disclosure to all of our left-hand panel, we can simply access it by clicking All Services up the top, selecting Queensland, and then finding our seller disclosure amongst the list here. If for whatever reason or purely by habit, we go straight into our property inquiries, which I'll do in this case, we'll have a little reminder and a direct link to the seller disclosure on this page as well, just down the bottom here. Cool, so I'll click into my seller disclosure now and walk you through those details. So click on my seller disclosure. Awesome, wait for the delayed. So here is our first landing page. So once this page is sort of loaded, we can enter or confirm our lot and plan or our title reference details. I'll go ahead and just use my little example here within our own system. Simply click on Lookup to bring up those details, and then click Continue once you've confirmed that. Internet death spiral. Come on, internet. There we go. Cool. So here we are on our first landing page. This is where we can order all of our certificates. As you can see, it's sort of broken up into 6 parts. So part 1 is seller disclosure, part 2, 3, 4, 5, and 6. All the relevant searches that you may require, obviously some additional for those particular sections on the form itself. So what I'm going to do in the case, I'm not going to rack up a big bill, so I'm just going to go ahead and order these particular searches here, our title and our plan, so we can generate the form and have a bit of a look. So I'll simply click on Order. Cool. Alrighty, the next milestone on the left-hand side will be to edit our self-disclosure form or edit our form. The seller disclosure statement will be displayed in the center here. And over on the right-hand side, we'll have our section breakdown. Firstly, you've got the seller, obviously seller and property details, title and encumbrances, land use, environment, buildings and structures, etc., etc. You can also click on each section to quickly navigate to it, or simply just scroll via the central panel here as well. On the form itself, it will currently pre-fill the seller and obviously the property details, obviously through your TriConvey Matter, all those details you entered in that first screen there. Here at TriSearch, and obviously the form itself is a work in progress. So we're constantly looking to automate as much as possible for the seller disclosure. So if I was to look into my crystal ball, I would predict sort of more automation to come. So this form is only going to get quicker and better as we continue to play with it. Currently, as it sits, there are active tick boxes and areas to expand if more, obviously, information or more text is required as well. You'll see your little little lines down the bottom here. We can simply expand the box by simply left-clicking and holding and moving that up and down. Once we're happy with the form, you've added or ticked all the information that was required, we can simply just hit Continue. This will save any changes and also bring us through to the review milestone. Fantastic. Give it a second load. Cool. This is where we can see all of our certificates that we've ordered here on this left-hand panel. We can additionally upload any additional files that we may need, either browse from our TriConvey or from your computer if required. For compiling the document, we can also drag and drop these files into a particular running order for anything that we may want to as well. At the end of each file, you'll see 3 little dots. So when I do click on these 3 little dots, I'll have the option to hide that particular document from the file. So if it's not part of the final compilation, then it won't be included when I do click compile. So if I wanted to hide this, it will simply be grayed out and now won't be part of that final compilation when I hit compile. Let's include the plan though. Cool. Once we're happy, we'll move on and we'll click compile. Once we've hit compile, we'll get a little notification up the top right-hand side just to let us know that the document has been compiled and saved into our Tri-Convey matter. And for our website-only clients, it will be listed under My Orders as seller disclosure compiled, which I'll show you in a second as well. So for our Tri-Convey clients, if I jump back into my particular matter, jump in here, you'll now see that all of our documents will be listed here below under all files or in all documents. If I need to make any amendments or changes to the form, I can access the editable document. Editable? I didn't say edible. Sorry, I'm struggling with English today. If I need to make any changes, I can access the document back through TriSearch. So obviously I might make a PDF within the software here, but to access it, I simply just go back into TriSearch, click on New Search again to generate my website. I'll just close this for a second so I can show you. Under the My Orders heading, we'll see the Queensland workflow and our seller disclosure compiled document. Simply click on that particular line item. That will load the page, where again, we'll have access to ordering any additional certificates. We'll list obviously every certificate that we have ordered already, or make any edits to the seller disclosure if we need to as well. One thing I just want to quickly touch on, and I'm sorry to jump the gun in regards to the Q&A, but I did see a question there from Tanya regarding DocuSign and compiling the document. So within Tri-Convey, and I'm just going to talk software specifically today, you will have an option to, if you click on the particular document, anything you want, seller disclosure, your titles, your plan, or whatever, you can create a multiple file PDF and condense this all or compile it all into one PDF. And you can utilize DocuSign or TriSign to then send that off to your clients as well. Equally, if I did want to send this via TriSign, you can access that via TriSearch and via your website, and where you'll be able to upload documents as well. So if you wanted to upload your contract and the compiled document and anything else, you can do that into one envelope. There is a limit, obviously, for your DocuSign envelopes. From memory, is roughly around sort of 10 documents. Depending on the size of the documents, you can fit into that envelope anyway. So apologies to jump ahead, but I just saw a question there that might be relevant to the software. So fantastic. And that sort of concludes our Form 2 seller disclosure demo. Thank you, Matt.
Thank you very much, Jeff. Thank you for the overview. Thank you for making it look so simple with your edible overview. Awesome. Everyone, that just about wraps us up for the formalities. What we'll now do is open up the floor to a live Q&A. In the final minutes, we will open up the floor. So if you do have a question for Nick, for Matt, for Jeff, please pop it into the Q&A box now. I can see that some people already have. I will, in order to get through them as efficiently as possible, I'll read these questions out and we'll answer them live on the floor. Anything we don't get to, we'll make sure we come back to you separately. Cool. I'll allow a couple of seconds for some more questions to populate and we'll start running through. I've got quite a long one to start with. I'll just expand it here. Okay. This one, I believe for Matt, potentially Nick, feel free to jump in, guys. So we are already experiencing a high volume of clients who wish to cut down search costs. Similarly, we are seeing Form 2s provided with minimal supporting doc and practitioners standing by that. Going forward, what is actually compulsory to provide? How much can we rely on the instruction/knowledge of the vendor? Are we exposed post-settlement as a firm if we take someone's word? Order no searches so we can save a few bucks and a non-disclosure issue arises. A few questions in there, but the same theme. Anyone want to have a crack at that one?
I'll have a go in terms of how we've structured it. So again, this comes down to your commercial model. So are you charging for the service of compiling the disclosure plus searches, or are you including it as an all-inclusive package? So I'll just premise it with that, because that might say, where you go to for your searches, whether you prefer the free ones or the publicly available information on behalf of your client, or whether you look to a more automated approach through, say, TriSearch. my view is we have a digital questionnaire and during the onboarding, we also give the client a digital questionnaire where we ask them the questions and we get their feedback and we talk to them about each of the different areas of the form too. If the client says, I don't know, or yes, our advice would always be that we take reasonable steps to do a search of a register or do a search on through TriSearch or whatever the platform you're preferring to use is. If the clients say no, not necessary, then at some point we have to be able to then, we just capture that advice both verbally and also in the questionnaire to say, yep, no problem, or but yes, as a default, we do the basic suite of searches regardless of what the client says, just to make sure they're covered. But I'd also be comfortable that if the client said yes or I don't know or didn't seem sure, that you would take reasonable steps to cover them on their behalf. So that would be my, I guess, legal approach. And I don't know if Matt's got any different opinion to that.
You're on mute, Matt.
It had to happen at some point. There you go. Look, I would agree with that approach completely. I think that's a very wise way. I would only add that I think it's really important to clearly set out in the retainer or the client agreement exactly the type of service that you're going to provide, and also make sure that that's communicated and understood. And that's part of that onboarding process that Nic talked about, kind of saying to the client, we need to do this. This is it. This is how we do it. If you want us to do it in a different way, let us know. If you don't want us to do the searches and you just want to go, no, there is no tree order with respect to this property and you don't want us to do a search on it, you just need to know that if you're lying to us, there's probably a termination right that will flow and that could scupper your deal down the track. And if that happens, so there's perspective in that. So I think the key thing is just to make sure the retainer that you're entering into the client agreement actually does set out the work you're going to do and the work you're not going to do, so that it's really clear to the client at the beginning. And that's probably one of the best defenses. And then doing what Nic's described is a great way of dealing with that. And then that first part of the question about what's in the regime, I think the thing is to go and have a bit of a look at what's in Section 5 of the property law regulation. And it just sets out the actual things that are the documents, especially for prescribed certificates that have to be provided. Not everything has to be provided. And it's only the things that are listed in the section that have to be provided. You can provide more. That is fine. There is no limit to the amount of documentation that you can hand over, and that's fine. And if you hand over or don't hand over a document that's not required, there's not a consequence that flows from that from a point of view of termination under the regime. But what has to be is only a limited list of stuff, because in setting up the regime, they started with a little bit of what do we already deal with? What's there already warranties? What can we already easily get to? So we start the regime in a way that tries to leverage a little bit of what's already easily out there or what's already known by the vendor. So, it's that thing. But scope the retainer, set up the client agreement, use those clearly setting out in that letter, whatever you want to use that sets out what you will do.
We made the mistake early of sending out the entire pack in one PDF. It's large to email and most clients won't have the capacity in their inbox to take it. The other one too is we found contracts are coming back for review at 200 pages of an REIQ contract with a disclosure. So what we've done is we send 2 packets to the agent and the client. We say, here's your Form 2 pack. This is the bit that needs to go with your contract. And then we send out a search pack, which is all the searches that we've done for the client. So the client has access to them, the buyer has access to them if the agent has possession of them if the buyer wants to see them. So they can sort of see the value that we've actually done the searches, but we're not we're not giving them stuff they don't need for the contract. So that approach has seemed to be working okay.
Yeah. Really good, gentlemen. As I'm reading through, there's a lot of common themes throughout the questions. One that keeps popping up, and it's more of a clarification of what you guys have just said, is the usual suite of searches. And just to clarify, the title search and plan is definitely mandatory. Also, the Section 206 body corporate certificate for body corporates, mandatory, but the rest is just as required. Is that correct? Nic?
I'm trying to get to the basis of your question. Yes, is effectively, I think, is the short answer to your question. But remember, the prescribed certificates, if anything's ticked yes, then the evidence of that becomes a prescribed certificate. So, and as Matt said, it's not just a search to say, yes, there's a QCAT proceeding on foot. It's the actual order as a result of that. It's the letter of requisition or the notice of land requisition. It's not just that you're on the TMR search, for example. The TMR search will say if there's a requisition, but it's the letter of requisition or the notice of requisition that would be the prescribed certificate. So, and again, depending on what you're covering in your retainer. So for us, we do the searches of all the registries just to make sure for our client that they're covered. But again, there is a time consumption to that.
Yeah, cool. I'll keep it going because I am conscious of time. We have one here from Lisa. Can the certificate/documents be attached to the contract and form part of the contract? So as at the date of the contract, there is no ambiguity as to whether the purchaser has received the docs.
My personal view is that I'm comfortable that they're in the same DocuSign packet. Form 2 to go first. Form 2, title search, survey plan, Form 33, Form 18, whatever you need, whether it's in Bugta or CMS, and then the contract. Saying it's attached to the contract implies to me that it's an attachment behind. That isn't good because it needs to be given prior to or at the time of contract. So I would have it first in a DocuSign envelope at a very minimum.
Yeah. Really good. We have one here from Rosemary. If acting for seller and no agent but buyer has solicitor, how should the disclosure statement be provided to the buyer? Can sellers send direct to buyer or should it go through buyer's solicitor and then does that comply?
Again, that comes down to your scope of work you're delivering, but it's on the seller to provide that to the buyer on or before contract. So that would be if your scope of your retainer was to have that to the buyer, then that's on you. Or you could contract out of that and make it the seller's responsibility and end your retainer at the delivery of the Form 2. But that's it's a question for your retainer and your scope of work.
Yeah. Here's an interesting one. What are the panel's thoughts of body corporate managers charging the prescribed fee for the Form 33 plus an hourly charge?
As I'm happy for us to charge, if it's a service they are providing, then I'm comfortable with them charging for that service. Yeah.
Cool. I'll keep scrolling through. What are your thoughts on time frame from when a seller disclosure inquiry is received to then issuing the Form 2, barring delays with search results?
This is probably on me again, Matt. I'll jump in. So that depends. So there's a couple of factors to that. So one is how quickly you can get the information back from your seller, how quickly you can get the water rates notice, because you have to do a search, you're delayed automatically. How quickly you can get your questionnaire back, your authority documents, and perhaps a VOI. If you get them back straight away, we've been having freehold Form 2s with all the required prescribed certificates and searches out 24 to 48 hours. That's quick. Body corporates with the delays in Form 33s have been a lot longer, but I suspect it's important that we're quick. I tell all my referral agents that you need to give yourself 10 business days just for planning, but hopefully we get it to you earlier. And we say to them, look, by the time you do your photos, by the time you set yourself up for listing, we're working in the background. If they engage us straight away, get the information to us straight away, we'll be back in time for you to launch the property.
Yeah, very good. Another one here. Is there a rationale why the Form 33 does not confirm the information regarding the body corporate implied warranties?
That's a Matt question.
Look, the Form 33 was one where there was a lot of fingers in the pie. A lot of stakeholder groups were involved in it. Ultimately, they wanted to try and create something that wasn't too far from the Section 206 statement that somebody mentioned before, which is now the Form 33, and create something that wasn't too far away from that. There's more information that could be provided, but it's the beginning point for the process. And so, it was created by consultation by the differing stakeholders with differing views about how much and what should be in there. And so what we know about disclosure material is you want it to be useful, but you also don't want it to be so long and so complicated that nobody will engage with it. And so that's the trade-off. How far do you go? The same thing happens with the general regime here. There's important information like flooding, which is not part of the regime. It's useful and important information. Some local governments have really great information and some don't. So that's probably one of the reasons why it's not mandated there. Doesn't mean it's not a good thing to look at and provide in many circumstances. Same sort of thing happened with Form 33. There's lots of different bits and pieces you could put in, but given the maturity of the industry supporting the body corporates overall, and the data that's held and the accessibility of the data, and then not taking it too far from the 206, you kind of get where we are at the moment.
Yeah, awesome. We're just about out of time. There's a few product questions throughout, which we may get back to people individually after the session. I'll take one more, and it's from Mitch. What are some of the more common statutory encumbrances you've come across, and any unusual unregistered encumbrances? Maybe one for Nic.
Yeah, we've had a client who had an agreement with next door neighbour for the cattle to access their driveway to access a rear paddock. So that was an unusual one. Just your leases. We've had some caveats. We've had some stat charges. We had a caveat over the property for proceeds of crime, which had to be paid out to the ACIC at settlement. So we've had a couple of little funny ones. I didn't realise they did that, but they do. So all the normal that you can think of are probably there. Your caveats, writs, stat charges. We've had all of those. And the cattle example was actually a long-term verbal agreement by the client's parents with the next door neighbour, and they were sort of long-term, neighbours. So that was an interesting one. So they're the kind of ones we've had, because that's a verbal agreement that needs to go on the form too.
Yeah, and what a great thing for the buyer to learn at that early point, rather than after they've bought the property, they've moved in, and the next door neighbour is bringing up a bunch of cows up the driveway, and you come out and go, "Why are you bringing a bunch of cows up my driveway?" You go, "Well, we've got an agreement. We've had an agreement for the last 20 years. We've got a right of use of the driveway." And then suddenly you find that you've got a whole lot of fertilizer for the garden that comes up every now and then.
Gentlemen, really good. We'll cap it there. We're over time. There are some unanswered questions in here, which we'll endeavour to get back to everyone individually. But first of all, I would like to thank our panellists for their time, for your preparation, and for your valuable contributions. All three, Matt, Nic, and Jeff, have volunteered their time to do this webinar to help with the educational efforts around seller disclosure and to hopefully make your lives as participants a bit easier. I would then like to thank each and every one of you participants for your time and for your engagement. The questions were great. I hope you can all walk away from this a little more knowledgeable than when you walked in. If you would like a personalised session of the tech solution, please reach out. That now concludes our session. Thank you again. Enjoy the rest of your afternoons.
Thank you.
Thank you.
Very much. Bye.